City of Joburg says it's going ahead with its plan to remove around 130 workers it says were appointed permanently illegally by the former ANC-led administration in the city. The workers are defined as political staff. As I understand it, normally they'll be appointed to a term linked to the administration. If the administration is voted out in an election, their contract ends. But the current DA-led administration says that the ANC-led administration broke the law when it made these appointments permanent before last year's local elections. Osborne Molatudi is a Labour lawyer at Molatudi Attorneys. He joins us now. Osborne, good afternoon to you. Normally it's quite difficult to just fire someone. Does the city's current administration have a case here?
Good afternoon, Stephen, and good afternoon to your viewers. Well, the answer may be it depends. It depends in the sense that what the municipal council is doing, and through its executive mayor, is that it is alleging that conversion of certain employment contracts, which were of a fixed nature, that they were irregular when their conversion was made from being fixed term to permanent. And on that basis, the municipal council will have to produce evidence to that effect in order to allow the affected employees to respond thereto. At the same time, I must indicate that the employer does have a right to review contracts within its workplace, be it of a fixed term permanent, and to assess whether or not any irregularity or irrationality attaches to any of those contracts. That they are entitled, and once they've gathered their evidence, they will be perfectly within their rights to approach a court of law to have those contracts or promotions set aside.
I'm no lawyer, Osborne, as you know, but I do follow our politics, or try to follow it quite closely. I mean, the idea is basically the ANC appointed their people, though their people would still be in offices now run by DA people. I mean, there's no way that can work, surely, on the face of it. It would seem that someone somewhere has a case here.
Well, indeed. I think the one key thing one needs to bear in mind is that an employment contract has to be between an employer and an employee. It will depend on the wording of that contract, whether it's one which aligns to the political office of the head, or one which is a true fixed term contract, or one which is of a permanent nature, that is a contract of indefinite period. So just to illustrate, coming to this case, Stephen, the affected employees have been given notices as to why their conversion from fixed term to permanent should not be rescinded. So they have the opportunity to rebut that allegation, so that at the end of the day, whoever is the executive mayor, could have been an ANC mayor doing the same thing, could have been a DA or the EFF or any other political party. They have to provide sound reasons as to why those representations made by the affected employees are to be ignored, or they have been considered but they do not make sense. Therefore, they are going ahead to rescind the conversion. The conversion will not be, I would imagine it won't be applied by a stroke of a pen. They will have to apply to a court of law to have those conversions and or certain promotions set aside by an appropriate forum, such as a court of law. This is exactly what the SAPC did. When it reviewed the so-called Hlaudi Mutshweneng appointments or promotions.
So in other words, if it turns out the jobs should not have existed in the first place, you can say this person should not have been contracted, should not have been given the permanent job when the job should not have existed. In other words, there shouldn't be a reward for illegality.
Yes, that may be the case, but in this instance, I doubt if there was no job. There was a job, it was a fixed term, then it was converted into permanent. Perhaps shortly before the local election, etc. One doesn't know what evidence has the current administration pulled in order to come to a decision that the procedure that was followed was irregular, and or the conversion of those fixed term employees was irrational or irregular. So there was a job, but the issue at stake here is the conversion of those fixed term contract into permanent contract, and that's the issue here. The good news is that the employees have been given an opportunity to respond. It will be naive to respond to the notices of invitation through media. I would suggest that they seek legal advice and or assistance in putting together appropriate, compelling reasons to the municipal council as to why their conversion from fixed term to permanent should not be set aside.
As I understand it, Osborne, this is the only time where this has actually happened. Joburg's the only council, certainly the only metro, where this has happened. Does that matter in that if you're the only one who's done something and now that's going to be reversed, I mean, does that strengthen the case either way?
It strengthens the case of the affected employees. If this is the first time, they can even cite that in their representation, that we find it strange that we have gone through so many changes in the political office of the municipal council. We have never had this before. Why isn't it being done? Our view is A, B, C, and D. And all of that should form part and parcel of their representation.
Yeah.
One other consideration, my apologies, Stephen, one other consideration is, to avoid a costly, legal, lengthy process, litigation, although they may ask for an expedited hearing, is why can't the parties sit around the table and see how best they can regularize these appointments and or promotions as to whether or not, there's a need for permanent position or continuation of fixed-term employment.
Well, Osborne, I don't know, but I think that might deny too much the politics of this. These are people appointed deliberately as political appointments by the ANC. Now you're asking a DA-led administration to take them on and keep them. I don't know if any negotiations actually going to happen. What I was trying to get to, and I sort of confuse myself with labour law sometimes, as I think you know, Osborne, is that I'm not aware of any other council that has made appointments like this permanent, as the ANC administration did. In other words, the DA might now argue the other way. This is the only time this has happened. These appointments should never have been made permanent. No other council has done it, and therefore we shouldn't do it either. Therefore, we're going to reverse the appointments.
Indeed, and that would be one of their solid grounds, one would imagine, once the formal process ensued. Because ordinary people and all of us as practitioners, we have always known that positions in government and mostly in departments are of a fixed nature. They are aligned to the office of the political head. They are aligned to whoever is in power at that point in time. As to why these fixed-term contracts were converted into permanent, only the adjudicator will have to determine that issue based on documentary evidence or oral evidence presented before him. You must keep in mind, Stephen, that the affected employees are claiming that the positions were advertised, there was a recruitment process, there was HR involved, there was legal involved, and from where we stand, our permanent appointments are above board. However, the municipal council could counter-argue and say perhaps there was collusion, etc. Exactly what happened in the SABC, because remember, in the SABC, on the look of things, one would accept that everything was done above board. But when you do what we call pierce the corporate veil, you then tend to come across certain irregularities, etc. That is why the SABC, in some respects, was successful. In other situations, it wasn't successful, especially where people were properly appointed or in situations where people were not properly appointed or promoted.
One of the really interesting aspects of this is that the people who were appointed, because they were political appointments, and frankly, Osborne, they must have known that they were political appointments. They would know that. They would know they were from the ANC. They would know they were being appointed to a political position in the council while the ANC was governing. What I'm trying to get to is that if someone knows that they are taking a job when the job itself shouldn't exist, or that what they are doing is being appointed illegally, does that change anything? I'm trying to get to, and this may be impossible to prove one way or another, I'm trying to get to what would have been in the mind of the person being appointed and whether they really had a legitimate expectation of retaining that job. I hope my question makes sense.
I hear you. It's more to do with knowledge of the offense well in advance, as well as whether there was any basis for legitimate expectation. I hear you. So that would be one of the issues that would require a fact-finding determination by the adjudicator. If indeed the affected employees had full knowledge that the process that they were going through was not regular, was not a proper process, was unlawful, and the current administration is able to prove that, then one will say they will face insurmountable legal challenges in not having this conversion declared unlawful.
In the back of all of this is the claim from the City of Joburg that it will save 80 million rand by letting go of these 130 people. The fact is, though, and I think this is obvious, is that they're going to replace them with their own people, who are also political appointments. And I imagine the city would say, well, the DA-led administration will say, but we're appointing them to a fixed-term contract, tie that term to the administration. So does it matter that these people who would lose their jobs are going to be replaced by other people who are other political appointments from other political parties?
I think I'll focus on the employment part of it. Politically, yes, things can be done strangely, Stephen, we all know that. But from a legal point of view, if there's going to be a vacant position, an employer is expected to really follow its own recruitment and selection procedure in filling those positions. And we know the traditional process. You advertise, you receive the CV, you shortlist, you do the interviews, etc. But one wonders whether when it has to be mixed with, this political interference or political interest, whether that same process is followed. But I would imagine that that's the process that they would have to follow in order to have the new appointments stand scrutiny.
Osborne Molatudi, always good to talk. Thank you very much indeed. Osborne Molatudi, an expert on labour law, as you can hear at Molatudi Attorneys. I do appreciate the time.